Hello, I'm Brian Lucareli, Director of our Private Client Services Group and co-chair of our Family Offices team at Foley and Lardner. And today I'm here with Tom Scannell, a partner in our Financial Restructuring Practice Group in Dallas. Welcome, Tom.
Good morning, Brian. How are you?
Great. So today we're going to discuss opportunities for acquiring distressed assets. As many of our audience may have heard through many of the media outlets, economists and other financial experts are predicting a potential recession either the second half of this year or potentially into 2024. And with that looming economic downturn that may or may not happen, we wanted to highlight some opportunities for all of you today to get when they want to get bullish, when others might get timid and miss out on a unique scenario to bolster their portfolio. But Tom, before we get started, would you mind just providing a little bit of your background, business background for our audience?
Absolutely. Like Brian said, my name is Tom Scannell. I'm a bankruptcy partner at Foley's Dallas office. And for the last 14 years, I have devoted the entirety of my practice to bankruptcy, insolvency, and financial restructuring matters. And part of what that includes is helping clients acquire assets from a distressed debtor. It's a really exciting and fun part of my practice because it's really helps a lot of the folks acquire opportunities and turn a positive result into something that was otherwise potentially distressing to a company and otherwise could be viewed as negative. I've really enjoyed this aspect of the practice because it helps provide a positive return, helps save jobs, and puts the assets to good use. So really enjoy talking about this, and I love this part of my practice.
Good. Well, thank you for the background, and I really like the topic today. So let's jump right into this, and let's start by getting a high-level understanding of the various ways a distress acquisition can be accomplished.
Sure. So there are four principal ways that assets are acquired from a distressed seller. There's an out-of-court acquisition, which is similar to your regular M&A deal. It's just done from a distressed seller rather than a healthy seller. You just got some additional risks and concerns to think about along the way, which we'll talk about here in a few minutes. Then there's two within the bankruptcy proceeding. There's a 363 sale. You think of that as a court-supervised auction. There's a Chapter 11 plan, which you can think about as a court-mandated or forced contractual amendment that is forced onto the creditors, and it can be used to sell assets. And then the last is a loan-to-own scheme, which you may have heard of before. It's a cute little phrase that people in the industry like to use, but basically you buy the debt and then you foreclose on the asset when the seller or your debtor cannot make the payments. The firm's group here in Dallas has recently helped clients acquire the going concern in Cece's Pizza and Corner Bakery through the loan-to-own scenario. So that's something that we're very familiar with and can be very helpful. But those are four principal ways.
Yeah, so let's start with let's jump right into the first one. What are the benefits to the out-of-court acquisition that you mentioned?
So as a summary high level, the out-of-court is normally quicker than going through the court process. It's cheaper than the court process. The buyer can maintain more control through the process because there aren't any other parties involved and you're not having to get court approval. And then you can have a little bit more privacy. So if you're going through the bankruptcy court, it's a public process. All the filings are on a public database, so you lose some of that privacy. So if any of those things are paramount concerns or driving concerns, you would want to think about trying to keep this out of the court process and maintain a little more control, and you can do it quicker and cheaper.
So are there any downsides to structuring an out-of-court acquisition?
There are. So in an out-of-court acquisition, other parties and interests are not bound by the terms of the agreement. So think of it like a regular asset purchase agreement transaction. It's only binding between the parties to the deal. So the buyer and the seller are bound by it, but no one else is. And what you really want to be concerned about here are two primary things called successor liability and fraudulent transfers. So if You buy all of the assets from a distressed company, you're probably going to leave them judgment proof without any operations and revenue. If they owe money to other people, those creditors might get mad. And if you leave the seller with no assets and no revenue, they'll be looking for any deep pocket to try to shake down.
Got it.
So even if you haven't assumed any liability, they can try to come after you for successful liability or fraudulent transfer. And what you get in the bankruptcy process is a court order that cleanses you and absolves you of any of that. So those are some downsides and considerations and risks if you're going to pursue an out of court acquisition.
So with all those risks in mind, when would it be more beneficial or cost effective to acquire distressed assets through a bankruptcy proceeding?
Absolutely. And again, with those risks in mind, those considerations, I would recommend going through a bankruptcy process. And if your seller is going to cooperate with you, then it can be done voluntarily. You don't have to force them into bankruptcy. But as a buyer, if any of those things are paramount concerns to you, you're gonna want to require that this acquisition be done through the bankruptcy process. And I would recommend any combination of the following three. You would want to do that and require that. So if you need to cleanse title to the assets that you're looking to acquire, say there's some liens or some mechanics liens or some other disputes that you're not interested in inheriting, you need the bankruptcy court's order to cleanse title to those assets. If you, like I said, if you have concerns about successor liability, you have some angry creditors out there that are looking to shake you down,
Right.
or if you think you're getting too good of a deal and someone might come after you and say you paid too little for these assets, they could shake you down for a fraudulent transfer. Any of those three scenarios, you're going to want to look at pursuing the bankruptcy process to acquire the assets.
So if the bankruptcy is a better platform that you mentioned, how does a transaction get approved by the court?
Sure. There are two ways that assets are sold in a bankruptcy process. There's a 363 sale and there's a Chapter 11 plan. So we'll
Okay.
talk about the 363 sale first. Think of that like a court supervised auction. The seller is the debtor. The debtor will file a motion with the court asking it to approve a process to liquidate its assets. And this can be done with or without a stalking horse bidder. Normally, if we're representing the buyer, then we would be the stalking horse bidder. We would set the baseline minimum bid after an appropriate marketing period, because you have to test the market in bankruptcy. There would be a deadline for qualified bids. And after that deadline passes, if there is more than one bid submitted in competition with the stalking horse bid, there would be an auction. And then at the conclusion of the auction, the court would approve the high bidder and then essentially approve the sale and allow the parties to go close the transaction at that point. It typically runs 60 to 90 days on average.
Okay. And you also mentioned the Chapter 11 plan?
Sure. And the Chapter 11 plan is like a court mandated contractual amendment that binds all of the obligations between the parties. And it can be used to dispose of assets and sell assets to buyers. And that's typically how the funds are generated to pay creditors in bankruptcy. I would note that you would want to use a Chapter 11 plan as opposed to a sale process if there's more going on in the case, or if there's more going on with your seller than normal. It's not just a simple, straight up transaction that you could close in and of itself. It's not an isolated deal. There's just more going on in the background. A plan can dispose of all those things in one fell swoop, as opposed to if you pursue a 363 sale, it just covers the sale transaction. So you're going to get the same protections, the same terms, the same opportunities. You would just use the plan to do it if you need to dispose of some other things in the background that could help you get that done. Again, around the same time frame, normally around 60 days, can be up to 90 or 120 if there are problems. And in very rare circumstances for good cause, it can be truncated to 30 days.
Tremendous insight here, but before I let you go, are there any other key considerations we didn't hit on that might be interesting to our audience?
Yeah, I'd be wary of the process. It's not a perfect process. It's very, very helpful, and we do it all the time. But I always like to warn clients when acquiring assets in a bankruptcy process that it's not perfect. You don't get any warranties like in a normal asset purchase agreement. So you take it as is, whereas no reps and warranties. You need to do your diligence entirely on your own because you're not going to be able to come back against the seller for anything that turns out not to be so. And then also secured creditors have a right to credit bid up to the full amount of their debt. So you're not going to get the assets for too good of a deal because ultimately secured creditors are going to be able to force you to drive your sales price for either an amount to take them out or an amount that they can agree to that is going to cover their interest. So be wary of those concerns. It's not a perfect process, but it's about as good as it gets.
Good. Well, Tom, I want to thank you for sharing your expertise and time today. And I want to thank all of you for watching our presentation. For more information, please visit us at Foley.com under Family Offices. Thank you.